you would see the system is very flawed. And yes, we get angry when we see corruption, but we also have to understand that corruption is infuriating, but it is also very complex. Just because there is corruption and you want to get rid of it, you can't get rid of it. Corruption is intertwined in legitimate activity. And to get rid of corruption requires a complex rules and regulations, how you intervene. And if you do it wrong, you can destroy regular markets. In trying to get at the corrupt market, you can destroy the regular market. I mean, we've seen that happen during the demonetization. The intention was good, but it did huge damage to the regular functioning economy by this intervention where the motivation was something else. So there are examples of this galore, and corruption was something, again, when I was in government, it is infuriating. You want to do something about, but you realize it's a very complex problem, intertwining with ordinary agents and with bureaucrats and their behavior. So it is a matter on which you need, of course, determination and courage, but you also need deep thinking, understanding the law and economics of enforcement in our country. Those were my sort of practical engagement. On another occasion, if there was more time, I would have spent more time on that. But I want to give you a little bit of my intellectual, academic side from which I came to this problem and this challenge. That has to do with many years ago. One particular topic, which is actually barely there in economics, interested me a lot. Power, political power, other kinds of power. If you read most of the economics literature, there is no reference to that, as if power does not matter. There are markets, there are prices, there are goods, there is trade and exchange, but power does not matter. But you know, if you've lived anywhere in the world, India, United States, China, wherever you are, power plays a major role. Someone is more powerful than another person, and that can make a difference to how the one person functions and how well off the other person is. But the power remains very, very poorly modeled. And economists have made a folly, in my opinion, because power is difficult to model. They have ignored power, and having ignored power, many mainstream economists forgot that power is important. They ignored it and they began pretending that it did not matter. I got a first glimpse of it, and that led me to my later work on law and economics. In I hope I'm getting the year right, 1983, 1984, visiting England, I met with, this was through Amartya Sen, my PhD advisor. I met with political philosopher, that's probably the best way to describe Stephen Lukes, who gave me a document, which was one of the most exciting documents that I had got. Václav Havel, who would later become the president of Czechoslovakia, that time was a revolutionary, opposing the authoritarian regime of Czechoslovakia. The iron hand of the government he was opposing. Václav Havel was in and out of jail. He was being put behind bars. He was being released. But he produced a slim little book called The Power of the Powerless. And over dinner at Oxford, Stephen Lukes told me that, asked me, I was that time very nervous, a young person with these great scholars sitting at dinner. Lukes asked me, what am I interested in? And I told him I'm interested in power and its relationship to economics. And Lukes said, in that case, you have to read a document that has been smuggled out of Czechoslovakia, because the person who has written it has been in and out of jail most of his recent years. That was Václav Havel's little book called The Power of the Powerless. And Havel describes in that book, it's not an academic's writing, so there is no game theory, there is no formal algebra, it's described in books. But let me give you a little bit of the book, because that's a style of analysis that I will use just now when I come into my formal analysis. Havel is trying to describe the power of the totalitarian oppressive state that Czechoslovakia was at that time. The Czechoslovakian economy was in shambles, but it was an authoritarian rule at the top. Havel's slim little book is in many ways a very generous book. He's not blaming any single individual for the calamity of authoritarianism. He calls this the post-totalitarian state, and the description is almost like a game theorist's description being given in plain ordinary language. And Havel is saying that to understand this his term is post-totalitarian state. To understand the oppression of this post-totalitarian state, you have to understand a few things. And he takes an example. A greengrocer, ordinary greengrocer, on the shop window, while selling onions and carrots and tomato and potatoes, puts up a poster. The poster is a declaration of loyalty to the state, that I am loyal to this authoritarian regime. And Havel asks the question that anyone who passes by the window and looks at this public declaration of loyalty to the regime will ask, is the greengrocer really loyal to the regime? Havel says no. In this country that I'm describing, which is his own country, that is not the case. This person is mimicking loyalty to this dreadful regime because if he did not show loyalty, others would begin to harass him. The school where his children go, the principal may suddenly one day call up and say that the children can't come to the school. The party cadres who run around all the time may begin to harass this greengrocer. So it is the fear of this that makes the greengrocer mimic loyalty to the regime. And Havel but goes on to ask the second layer question, which is actually the way game theory operates. He says, but it's not good enough to understand the greengrocer's behavior. Why will those people who would harass the greengrocer, if the greengrocer did not display loyalty, why will they harass the greengrocer? And Havel gives the same answer. They will harass the greengrocer not because they are loyal to the regime, but if the greengrocer is disloyal and they don't harass the greengrocer, they will be described as disloyal to the regime and others will harass them. And it's that fear that makes them harass the greengrocer. And it's that fear that makes the greengrocer mimic loyalty to the regime, and everyone is caught in this trap. Havel's description is a generous description because there is no good or evil. Society is caught in this trap. Everyone mimicking regime, and therein comes the power. That is something on which some of the people who may know some of my works, I had done a very early paper called One Kind of Power in Oxford Economic Papers. When I used to live in India, I had written this paper. I return to this now because with the writing of this book that I've done called The Republic of Beliefs, I come back to many of these topics. So this is a long preamble. Let me get into the subject of law and economics. And I will show you that some of the power of the law is the same kind of power that Havel is describing. But of course, I'm doing as an academic. I want to stitch up the argument, which for Havel was an intuitive, broad description. I do it formally, using analysis, using game theory. I should tell you, some of the audience will be disappointed that I will not be able to do the formal analysis in the lecture, but probably many of you will be relieved that I'm not going to inflict formal mathematics on you. I will give out the argument as clearly as possible in words, but there is my book. And by the way, I discovered that you can shortcut my book. I just read a lovely review article of my book in Indian Economic Review by Ram Singh. Ram Singh gives a summary of my argument even better than I could have given. So if you want a shortcut, you can read the article by Ram Singh in Indian Economic Review in 2019. The article is also called The Republic of Beliefs, where he reviews my book. That's a summary. But let me come back now. Conventional law and economics does not show the insight that Havel showed, and I think makes a mistake, which puts it on a weak footing. I'm just thinking of the order in which I will take you. Yeah. By conventional law and economics, I take it to be, and I think most people take it to be, it's the work in the United States that took place in the 1960s. Law, of course, is an ancient discipline, going back, in fact, hundreds and thousands of years to early documents, to Chanakya, to Mesopotamia. People were writing down laws. But the interface between law and economics is relatively modern. Americans were using this right from 1890, when the Sherman Act is enacted. But the theory, the foundations, happens over a 10-year period. Basically, in the 1960s, a couple of papers, the most important being the work of Gary Becker, by Ronald Coase, and Guido Calabresi of Yale University. I will use Gary Becker to illustrate the foundations of modern law in economics, and also then to point out that there is a fundamental flaw in the foundations of law and economics, which makes us enact law poorly, which makes our laws not be enforced well. And as an academic, we have a responsibility to understand the foundational flaw and try to rectify that. And that is what I will do over the next 20 minutes or so of my lecture that remains. Consider Gary Becker's theory. I'll give it to you fully in words. Why does the law change behavior? Gary Becker will say that the law changes behavior because the law changes the game of life. When you undertake some action, the payoff that you expect, the return from that action, that may change when a new law comes in. And if from action A, the return changes, you may decide not to go for action A. So the law, by changing the payoffs of different actions, can change your decision, how you behave. That's why the law is effective. One example I'll give you, speed limit law, driving. You are driving from, let's say, Gandhinagar to Delhi. You're doing a long distance drive. And you are calculating at what speed you are going to drive the car. Let's say that there is no speed limit law in India. You will do some mental quick calculation. If you drive very fast, you'll reach fast, but there's a risk that your car will skid, there will be an accident. You do the cost-benefit analysis, and you decide that on highways where there's no other traffic, you are going to travel at 120 kilometers per hour. Let us say that's the decision. You should drive a bit slower than that, but this is just an example that you've decided that there's no law. Your own decision is doing cost-benefit analysis, saving time, risk of accident, etc. You'll drive at 120 kilometers per hour. Now, suppose that a new law is brought in that anyone who drives above 100 kilometers per hour will have to pay a fine of a certain amount of money. Let's say, let me over here, I don't want to get into complications, that you'll be caught for sure. The police are very effective. They are driving around everywhere. If you drive faster than 100 kilometers per hour, you'll get caught. You'll have to pay a fine of F dollars or F rupees. If you're paying a fine in India, F rupees, in America, F dollars. That's the new law. And Becker's answer is very easy. You're going to then, once the law comes in, your payoff from driving fast changes. Earlier, when you were driving at 120 kilometers per hour, you would save this much time and there would be the risk of an accident. Those were the costs. And the saving of time was the benefit you were calculating. But now with the law, there is a change. There is an additional element that has come in. And what is that additional element? That you may be caught, and for simplicity, I'm assuming you will be caught once, and you'll have to pay a fine of F rupees. So now the benefit remains the same of driving fast, but the cost of driving fast increases. Earlier, there was the cost of accident, risk of accident, but now there is the cost of the fine. If this total cost is very high, you will say, no, it's not worth driving at 120 kilometers per hour. I will drive at 100 kilometers per hour. So the law changes your behavior. That, in the nutshell, was Gary Becker's famous paper, Crime and Punishment, Journal of Political Economy. And it really, I don't again have time. I don't want to decry that. This view is an extremely important idea, and lots of new rules of the game, the American drafting of the law, etc., is founded in this kind of a Beckerian idea. And there are very similar, very powerful ideas by Guido Calabresi, by Ronald Coase, which influenced American markets and functioning. And for the most part, when there is a flaw in an argument, it's not that everything will go wrong, but a few things will go wrong. There is one flaw in the argument, and that is what I want to focus on. What is the flaw? It is the following. After the law is enacted, if the police stops you when you drive fast, of course, your payoff from driving fast changes. But you have to ask another question. If the law is made that you're not allowed to drive above 100 kilometers per hour, there is a risk that the police will catch you. But you have to ask, why will the police catch you? Just the way you explained your behavior, you'll now drive slower by saying because the police will catch you, you have to also explain the police person's behavior. If there is a law saying you're not allowed to drive faster than 100 kilometers per hour and you drive much faster, why will the police catch you? To answer that, you have to look for something similar. If the police does not catch you, maybe the boss of the policeman will catch the police person and fine the police person for not doing his job. Or maybe if the police person does not do that, in the long run, the police person will not be promoted by the police person's boss. But then there's another open question. Why will the boss behave in that manner? You can say the boss behavior will in that manner because otherwise the magistrate will punish the boss. But then the question opens up, why will the magistrate punish the boss? And to put it fundamentally, and this in 1989 and 90, I gave some lectures in Princeton University, which came out in a slim book called Lectures in Industrial Organization Theory. The book discussed antitrust legislation, and right at the tail end of the book, the last chapter of the book, I wrote down about something that was troubling me, and that's the something that I'm telling you about. See, one problem with the law being so powerful is, you ask the question, in the end, what is the law? The law is nothing but a group of people having a discussion, maybe in a parliament or an assembly, and writing down a few things. If someone drives above 100 kilometers per hour, that person will be fined 2,000 rupees. That's the law. The law in the end is a few words written down on paper. And then that leads me to the question, why will a little bit of ink on paper, writing down a few things, change my behavior, the police person's behavior, the judge's behavior, the prime minister's behavior? Everyone's behavior gets affected. But in the end, the law is completely vacuous. It's nothing but some words on paper. If all of us collectively decided to look the other way, then the law would do nothing. The mistake that Gary Becker was making and the Chicago School makes is the Chicago School assumes that ordinary individuals are all rational, profit-maximizing agents. When I drive from Gandhinagar to Delhi, I'm calculating my time saved, risk, etc., and I take a rational decision. But they were assuming that the policeman, the bureaucrat, the politicians are programmed creatures. As soon as there is a law, they enforce the law. If you allow for the fact that all the agents in society are agents, individuals like you and me, the way you are explaining my behavior, you have to explain all of their behavior. You have to bring everyone into the description of the game of life that we are playing. If we do that, you run into trouble. There's no easy explanation. The law is nothing but a few words scribbled on paper. Just those words on paper should not change the behavior of the judge, the police, the magistrate, me. Why does it happen? That's the big open question. And trying to answer that question, I think I found an answer. And my book, The Republic of Beliefs, is a statement of the new approach, which I call the focal point approach. I should point out, it is new. I had begun working on this with the work that I did during my Princeton lectures, but there I just talk about the puzzle. I had no solution. There are prominent authors who have been onto similar ideas. I should mention prominently because there are lawyers and economists. Among economists, George Melath, Stephen Morris, Andrew Postlethwaite have very, very similar ideas. In law, you encounter similar ideas, but the writing style and all is different from mine because of a disciplinary difference. But Cass Sunstein, Eric Posner, Richard McAdams in Chicago University, to a certain extent, Bob Cooter in Berkeley, these were legal scholars onto a very similar idea to what I'm expressing. Now, the question that I want to answer, for which I will have to do a little bit of sharing of screen. It'll be very little bit of this I will inflict on you. Let me see if I can do it successfully. The sharing. I want to show you that just ink on paper can make a difference to people's decisions. That's what I want to do. Okay. Krishna, because I'm seeing your name, I'm asking you, but to anyone, are you seeing my sharing of screen? Am I doing this right?
Sir, it's coming. It's saying that it's starting to share content.
Okay. So
yes, sir. Now it's visible.
Okay, very good. Then it's just 2 or 3 pages of sharing I'm doing. It's messing up my own screen. Is Streamlabs YouTube? Okay, let me just see if I can make it a bit better for me to look at. No, but I've got some printouts of the page, so I can tell you. I'm wondering if I will do this with this example. Yeah. The notion, the law is useful, I argue, for a very, very seemingly vacuous reason. But actually, as you think about it, you'll feel persuaded, I like to believe, that it seems vacuous, but very powerful. In the end, the law is powerful, not because of the brick and mortar power of law, but because those few words scribbled on paper can change my expectation of what you will do, your expectation of what you expect me to do, my expectation of what that politician will do. It changes our beliefs about one another. It can. If the law changes our beliefs about one another, then bringing in the law can change behavior. That's the idea. Trouble is, it's very difficult to quite understand how human beliefs are very strange. We have a capacity to anticipate what someone else is thinking, and that person has a capacity to understand what I'm thinking. The first glimpse of this occurred in the classic book of Thomas Schelling. I'm basically using 2 sets of ideas: Schelling, John Nash, and I should tell you, Václav Havel. He's a revolutionary activist and later a president of the country, of course, but a great thinker. So these are the 3 backdrop of thought. Now here is Schelling. Schelling shows that how the human mind has the ability to coordinate with one another. It's a mysterious thing, but it happens. Now look at this picture. This is a game, literally a game of the kind that John Nash discussed. Let me just expand it and get it larger. I don't want to mess it up. Yeah. 2 soldiers have been parachuted down in an enemy territory. So you've been dropped in an enemy territory, and the 2 soldiers have been dropped, and the 2 soldiers have to meet. If they can meet, they are from the same country. They've been dropped in another country. There's a war going on. If these 2 soldiers meet, they will defeat the enemy. But if they don't manage to meet, they are going to be killed. So this is a game. Each of these soldiers who has been parachuted down has this map of the region where they have appeared. So soldier A picks up and sees this map in the hand, and soldier B looks at this map in the hand. By the way, please ignore this Cornell University logo that has come in. That was not the intention. It has somehow slipped in my preparing of this picture. Now, think of yourself as one of these 2 soldiers. You are desperate to meet the other person, and the other person is desperate to meet you. You have to choose some place on this map where you will go and stand, and the other person has to choose some place where the other person will stand. If both of you choose the same place, you have won. You will defeat the enemy. That's victory. If you choose different places, one of you is standing near the tree and the other is standing near this house, you will lose. You'll be defeated. This is a game. And I will also tell you, some of you will know the notion of a Nash equilibrium. A Nash equilibrium in a game is a choice by the 2 players such that, given the other player's choice, and your choice, you have no regrets with your choice. You don't want to change it. If both of you choose the same place, that's a Nash equilibrium because you will win. If you choose different places, that's not a Nash equilibrium. Having said that, it should be clear that this game has lots of Nash equilibria. Any place where both of them choose, that's Nash. So this is riddled with Nashes. Question is, which one will you choose? And the answer is there's no right or wrong answer. That the human psychology is such, look at it yourself. Another person has come into this area and you're trying to go and stand somewhere where you're hoping that the other person will also go and stand. Will you stand near the house? Will the other person come near the house? You don't know. You're trying to choose. Think for a moment, which place will you choose? And I'll give you the answer. There is no right answer. But Schelling had shown that a majority of people choose. And I have done this experiment in my class lecture theatre and asked students, don't consult with anyone, choose a place in the hope that others will choose that place. Most people choose the bridge area. They'll go and stand in the bridge area. In fact, 7 out of 10 in Schelling's experiment choose the bridge area. And in my classroom also, it's very close to that. Roughly 7 out of 10 people choose the bridge area. This is the strange capacity of the human mind to coordinate, and that allows for, this is called a focal point, a Nash equilibrium, which is important, salient, and you can guess that the other person will guess that is called a focal point. And my belief is that that's all that the law does. It creates focal points in our head. And I'll give you one more example of a game where the little bit of ink on paper is going to actually change people's behavior. So I want to illustrate to you how ink on paper can change behavior. This is the squares game. The squares game is the following. Give me one moment. I'm just checking on what I need to cover. Okay, I'm going a bit slower than what I had intended to. So, okay. This is the squares game. In the squares game is the following. You and another person are playing this game, and you have to choose one square, any one of these 16 squares, and the other person has to choose one square. If both of you choose the same square, you'll get $100, or let's say 5,000 rupees, each of you. If you choose different squares, you'll get nothing. This game has lots of Nash equilibria. Any square, if both of you choose, that's an equilibrium. There is no reason why you will say, gosh, I should have done something else. If both of you choose the same, you're going to get the money and you're happy. So this game is full of Nash equilibria. If both of you choose this square, you will both get 5,000 rupees. If you choose this square, you'll get 5,000 rupees. But therein lies the problem. Which one will you choose? You don't know. And you don't know what the other person will choose. If you make people play this game, repeat it just in a classroom setting, say once, it'll be all over. Someone will choose this square, someone will choose this square, someone will choose this square, someone this square, it'll be all over. Now, let me do something to the game. I won't change anything real in the game, but I'll spill a little bit of ink on this board. Here is ink on paper. This square, I have put in a little bit of blue ink. The game is exactly the same. The ink makes no difference to the rules of the game. If both of you choose the same square, you'll get 5,000 rupees. If you choose different squares, you'll get nothing. The color does not matter. So the game is exactly the same. Do you know how most people would play this game if I gave them with this board, with ink having fallen on one square? I'm asking you to choose, and you're trying to choose one square, thinking very hard, I want to choose a square which the other person will choose. The other person is also looking at the same board. It's very likely, 90% chance, you will choose the square with the ink on it, and the other person will also choose that square. The ink gives it salience. It does not change the rules of the game. It makes you believe that the other person will behave in a certain way and makes the other person believe that you will behave in a certain way. And in the end, I would argue that the I'm going to stop sharing. The screen is slightly distracting of me, and then go back to my story. Let me see how I can. Sorry, I'm making a bit of a mess. I don't know how to go back to that. If I can't, there's you're sharing. Okay, stop sharing. Let me see if that, yeah, that's restored my screen. I wanted that screen is distracting for me. So what I'm now claiming is that what happens with the law is once the law comes in, I expect the police to behave in a certain way that the police will enforce. The police expects that if the law is there and the police does not enforce it, there'll be someone else who will punish the police. And it's this locking in of beliefs which causes the law to be effective. This is called the focal point approach, which I want to push. And I feel that is really the crux of the matter. This gives you certain very, very deep insights into why the law is effective in some situations, why the law is not effective in some situations. First of all, a law has to be clearly articulated. What it says, which square is it asking you to go to? The articulation is extremely important. Number two, what can happen is, if there is already a focal point in society, that is, you have certain expectations of how other people will behave, and other people have expectations of how you will behave, then if a law comes in which asks you to behave in a different way, the law may not be effective because the society had a natural focal point and that focal point gets disturbed. That can also destroy the functioning of the law. And one example from history, Indian history, is an important one that I will give you. There is a very beautiful paper by Anand Swami and Rachel Cranton. When the British arrived in India in the Bombay Deccan, they were seeing that money lending used to happen clumsily. People had certain rules of behavior, but there was a lot of defaulting, running away. So the British brought in the British law for the enforcement of behavior in the credit market, in the usury market. And Cranton and Anand Swami point out that what happened as a consequence of this is actually the credit market began malfunctioning. It was doing even worse after the British law came in. And I believe the reason is in countries where there are long-standing customs, like in India. India is a country with a long history. So we have our norms, we have our social customs with that. And when you now bring in the law, it's like having two focal points. In that squares game, if I had one square marked blue and another square marked red, and then I asked you to choose any square, there would be mismatch of behavior. So in societies in which there are long-standing norms, when you now bring in formal laws, it's almost like there being two focal points, and that can cause a conflict of behavior. This is broadly the approach taken, and I believe that from enforcement of child labor laws to corruption control, if you take the focal point where you are not treating the policeman, the bureaucrat, the politician as moral agents or robotic agents just doing their jobs, but they are also rational. They are also maximizing whatever they are maximizing. Once you create this huge general equilibrium system and trying to elicit ideas of law out of that, you will get a much better grinding in that. I will just close by literally by taking 2-3 minutes by saying, taking you into another area where I've begun working. I've got a bit of PowerPoint on this, but I'm not going to inflict that on you. This is about group responsibility. Most of the law talks about individual behavior, individual responsibility, but I'm currently working on group behavior. When a group of people behave immorally, who do you hold responsible? If you take this approach that I'm giving into group immorality and who do you hold responsible, This is something that, of course, there's a big literature in law in United States in group moral responsibility, in philosophy, from Dworkin, the legal scholar, to philosophers. There's a big literature. You can begin to get very, very deep insights into group bad behavior and group immorality. But I have taken more time than I had intended to, presenting the bare sort of broad structure of the argument that I present. So I'm going to stop with that. And if you have questions, I shall be very happy to take.
Thank you, sir, for a valuable session. Before moving forward with the question answer session, I warmly welcome Professor Dr. Sanjeevi Shantakumar, sir, Director of Gujarat National Law University, and request him to thank Professor Dr. Kaushik Basu, sir, with his few words.
Good morning, sir. In fact, it's late in the night to you, but still, I deem it a great honor and privilege to be a part of this program, and I'm really great that my day started with listening to your wonderful presentation on this subject. I'm really fortunate, sir, and thank you so much for accepting our invitation and being a part of this program and enlightening our scholars and students and the research scholars here with your thought-provoking address on this law on economic analysis of law, whatever it is. So we are really grateful to you, sir. I don't have appropriate words to express my gratitude and thanks to you for accepting our invitation and for spending such precious moments with all of us today. Thank you so much, sir. We are highly grateful to you. We look forward for your continued support and guidance to help this Center for Law and Economics grow to the heights that is possible. Thank you so much.
Thank you very much. I would have loved to have stayed on for your ongoing sessions, but it's inching towards 12:30 at night. So if you will pardon me. Yeah.
So we are extremely grateful to you, sir, for spending time at this odd hour of your day. Thank you so much.
Interacting. Yeah. Okay. Bye.
Thank you, sir. So if participants have any further questions, then I request them to post the questions in the chat box along with the names.
Professor Basu, thank you so much for the amazing session.
Ranita, yeah.
Can you hear me? So, sir, my question was this. Can you hear me, sir?
Yes, I can hear you. Yeah.
Yeah. So my question is this. We can have, two focus points within the example that you told us, that there could be a contradiction between two equilibriums. In your example of norms versus formal laws, would over a period of time, in the dynamic equilibrium analysis, would it be possible for the formal law to actually change the norms such that there's a new equilibrium where both converge? And what would be the forces that determine the dynamic convergence compared to the divergence, remaining in place? That would be my question.
Ranita, actually, very good question. And we don't fully understand it, but in the end, a country becoming law-abiding is where the law gradually emerges as the sole focal point. So in the beginning, there are many focal points. And many focal points means the purpose of the focal point is defeated. You're expecting something, I'm expecting something else, and there is a mismatch. But countries that have become law-abiding is because gradually the focal point becomes dominant. Now, the legal focal point becomes the dominant one, the formal law. Quite how that convergence occurs, no one fully understands. There is a remark by Gordon Brown, the British Prime Minister, which was a jocular remark, where the British Prime Minister points out that the hardest part of the rule of law are the first 500 years, meaning that it actually takes very, very long for the convergence to occur. But people have argued that ordinary people, they want to see if the law has a legitimacy, if the law has moral appeal. Those kinds of things in the long run gradually give salience to the law, and then the law becomes the dominant focal point. But there is no guarantee. There are societies that have remained anarchic over hundreds of years, thousands of years, but there are other societies that have managed. So we don't fully understand it, but we know that that is what we have to strive towards. But that is the kind of agenda, research agenda, that opens up with the use of the focal point approach.
Thank you, Professor. Thank you. Very interesting new area for further research. Thank you.
So. Thank you.
We'll be in touch with you.
Okay. Thank you very much.
Thank. Am I audible?
Yes, Krishna, you are.
Yes, sir.
Yes, Krishna, audible.
So, sir, I apologize for the technical glitch that happened from my end. So moving forward, taking cue from the valuable plenary session that was delivered by Professor Dr. Kaushik Basu, it is manifest that law and economics as a discipline could scientifically help in resolving the problems in this society. On this note, it gives me immense pleasure to welcome everyone for the inaugural session. Once again, I extend my welcome to Professor Dr. S. Shantakumar, Director, Gujarat National University, Professor Dr. Mamta Biswal Ma'am, Dean of Academics and Faculty Affairs, Professor Dr. Ranita Nagar Ma'am, Head of the Center for Law and Economics, Dr. Hiteshkumar Thakkar Sir, Convener of the conference, all esteemed faculty members, distinguished guests, luminaries, and participants, to engage themselves with the exchange of thoughts and deliberations in GNLU International Conference on Economic Analysis of Law and Governance from 18 March to 21st March 2021. For this inaugural session, I'm pleased to tell that we'll have a guest of honor, Shri Injeti Srinivas, Chairman of IFSCA. It is my privilege now to welcome the driving force behind this conference, our Director, Professor Director, Sanjeevi Shantakumar Sir. Sir's area of specialization are environmental law, human rights law, international law, and constitutional law. Sir is a recipient of several prestigious awards, such as Environmental Law Champions Development Award from Asian Development Bank and the Best Social Scientist Award from the Indian Society of Criminology. We invite Sir to inaugurate the conference.
Thank you, Krishna. Am I audible?
Yes, sir, you are audible.
Thank you. Honorable Shri Injeti Srinivas, Chairman, International Financial Services Authority. Professor Dr. Kaushik Basu, Professor of Economics and Karl Marx, Professor at Cornell University. My esteemed colleagues, Professor Dr. Mamta Biswal, Dean Academics at the Gujarat National Law University, Professor Dr. Ranita Nagar, Conference Chair and Head, GNLU Center for Law and Economics, Dr. Hiteshkumar Thakkar, Assistant Professor of Economics, Gujarat National Law University, other distinguished faculty colleagues, participants in this conference, ladies and gentlemen. Good morning to each one of you, and I take this opportunity to extend a very warm welcome to all of you to this conference. At the outset, I wish to place on record my sincere appreciations to the GNLU Center for Law and Economics especially the head of the center, Professor Anita Nagar, and other faculty and student members of the center, for organizing this Young Researchers and Scholars edition of the International Conference on Economic Analysis of Law and Governance. I wish to start this address by quoting Justice Oliver Wendell Holmes, one of the most influential American judges, who in his work on the path of the law said that for the rational study of the law, the black-letter man may be the man of the present, but the man of the future is the man of statistics and the master of economics. I clearly understand that the principal object of this conference, aimed at young researchers and scholars, is to create those women and men of the future who will be the master of economics, who will be able to contribute significantly to the rational study of the law. I'm also reminded today of Judge Richard A. Posner, who once said that, to me, the most interesting aspect of the law and economics movement has been its aspiration to place the study of law on a scientific basis, with coherent theory, precise hypothesis, deduced from the theory, and empirical tests of the hypothesis. According to Posner, law is a social institution of enormous antiquity and importance. And he says that I can see no reason why it should not be amenable to scientific study. And he says that economics is the most advanced of all social sciences, and the legal system contains many parallels to and overlaps with the systems that economists have studied successfully. According to Posner, a rational decision making which maximizes the efficient use of resources is the stated objective of economic analysis of legal problems, and efficiency becomes the standard for all proposed solutions and is measured in terms of maximized value, which in turn is a function of the willingness to pay. Hence, the need for this discipline called economic analysis of law, which concentrates on the application of microeconomic theories to the analysis of law. Economic concepts are used to explain the effects of law, to assess which legal rules are economically efficient, and to predict which legal rules will be promulgated. The field of economic analysis of law is not something new. We have literature which says that it has begun with Bentham even in 1789, who systematically examined how actors would behave in the face of legal incentives and who evaluated outcomes with respect to a clearly stated measure of social welfare, what he called it as utilitarianism. Bentham's writings contain significant and extended analysis of criminal law and law enforcement, some analysis of property law, and a substantial treatment of the legal process. His work was left essentially undeveloped until 1960s and early 1970s, when interest in economic analysis of law was stimulated by four major contributions. The first of which is Nobel laureate Ronald Coasse's article on externalities and legal liability, Gary Becker's article on crime and law enforcement, Calabresi's article on culminating, sorry, I'm not getting the name of that article. It was on accident law. And Richard Posner's general textbook on economic analysis of law and his establishment of the Journal of Legal Studies. Research in economic analysis of law has been active since 1970s and is accelerating. And today we are here participating in this international conference on economic analysis of law to encourage and motivate more and more young researchers and scholars in the field of economic analysis of law. Law and economics, also known as the economic analysis of law, differs from other forms of legal analysis in two main ways. First is the theoretical analysis focuses on efficiency, which is very, very vital for any legal system, for any nation, for any economy. Therefore, the law and economics stresses that markets are more efficient than courts. When possible, the legal system, according to the positive theory, will force a transaction into the market. When this is impossible, the legal system attempts to mimic a market and guess at what the parties would have desired if markets had been feasible. The second characteristics of law and economics is its emphasis on incentives and people's responses to these incentives. For example, the purpose of damage payments in accident, for example, the tort law, which Professor Kaushik Basu also spoke about. The purpose is not to compensate injured parties, but rather to provide an incentive for potential injurers to take efficient, cost-justified precautions to avoid causing the accident. So law and economics shares with other branches of economics the assumption that individuals are rational and respond to incentives. When penalties for an action increase, people will undertake less of that action. Law and economics is more likely than other branches of legal analysis to use empirical or statistical methods to measure these responses to incentives. Law and economics scholars, they also apply the tools of economics such as the game theory to purely legal questions such as various parties, litigation strategies. While these are aspects of law and economics, they are of more interest to legal scholars than to students of economics. I am confident that this conference will provide all the participating young researchers and scholars a wonderful opportunity to learn from very eminent scholars like Professor Kaushik Basu, Nobel laureate Professor Oliver Hart, Professor Thomas Ullen, Professor Ram Singh, Mr. Injeti Srinivas, who is present with us today morning, Professor Ajit Mishra, Professor Panta Murali Prasad, Professor Javir Singh, Professor Rajesh Parche, and of course our own professors, Professor Ranita Nagar and Professor Hitesh Thakkar. My sincere appreciations to Professor Ranita Nagar and her team at the Center for Law and Economics for organizing such an intellectually stimulating event today. I wish the conference a grand success and thank you very much for giving me this wonderful opportunity. Thank you. And I take this opportunity to personally welcome Shri Injeti Srinivas to this conference. Welcome, sir.
Thank you, sir, for your inspiring words. It's my privilege to warmly welcome Shri Injeti Srinivas, sir, Chairman of International Financial Services Center Authority. At that note, I would like to invite our head of the Center for Law and Economics and Professor of Economics at GNLU, Professor Dr. Ranita Nagar ma'am, to give us a glimpse of forthcoming days of GNLU International Conference of Economic Analysis of Law and Governance, with an insight on the work done by the Center for Law and Economics at GNLU. We invite you, ma'am.
Thank you, Krishna. Respected guest of honor for the conference, Injeti Srinivas, sir, Chairman, IFSCA, Professor Thakkar, Director, Gujarat National Law University, Professor Mamta Biswal, Dean Academics, Dr. Hitesh Thakkar, Conference Convener, GNLU faculty, distinguished guests, participants, and my dear students, I wish you good morning and a very warm welcome to our conference on economic analysis of law and governance. Over the past few years, the Supreme Court of India has expressly dealt with the interface between law and economics in some notable cases. One such recent case is the judgment of the Supreme Court in Shiv Shakti Sugar Mills versus Sri Renuka Sagar case, and Justice Chandrachud's dedicated segment of law and economic analysis of right to privacy in the recent judgments. Also importantly, in the recent few years, the majority-led Government of India has witnessed significant policy reforms and associated legislations such as Real Estate Regulation and Development Act, Insolvency and Bankruptcy Code, labor laws, farm laws, etc. We heard from Professor Kaushik Basu the genesis of law and economics in the developed world. So I will not repeat that, and I'll talk a bit about law and economics in India. So it was the year of 1990 when Professor Hans Bernd Schaeffer and Professor Klaus Ott of the University of Hamburg visited Hyderabad for a 3-week course on law and economics organized by the Center for Economic and Social Studies in collaboration, and it marked the entry of the subject into the Indian academia. Since then, India has seen academic experts like Professor Kaushik Basu, Professor Satish Jain, Dr. Y.V. Reddy, former Governor of Reserve Bank of India, contribute to law and policy as evidenced in the era of New Economic Policy 1990. As India got entrenched in the dominant market economic policies, it became more and more important to teach, research, and train in this growing domain. The GNLU Center for Law and Economics was established in 2015 under the guidance of Professor Bimalan Patel, the former director of Gujarat National Law University. The center, thanks to the sustained efforts of its faculty members, namely Dr. Thakkar, Dr. Richa Sharma, Dr. Maris Port, have contributed towards teaching, research, extension, and training activities in the domain of law and economics. The center continues its research efforts under the inspiring guidance of Professor Dr. Santhakumar, Director, Gujarat National Law University. On the teaching part, among the national law universities in India, GNLU was among the first to introduce the subject of law and economics as core subject papers offered to undergraduate students of BA, BBA, and BCom. In the domain of extension and training, the center has had the privilege of hosting multiple guest lectures and certificate courses by national and international experts like Professor Hans Bernd Schaeffer, Professor Thomas Ulan, Professor Tom Ginsberg, Professor Upendra Bakshi, Justice Sikri, former Supreme Court judge. The center has also organized 1-week academy on specific areas of economics and multiple research methodology workshops. Under the extension wing, the GNLU Center for Law and Economics has been instrumental in establishing the Indian Association of Law and Economics in 2016. The Indian Association of Law and Economics, which culminated because of the initiative of Professor Prasad from IIT Kanpur, Professor Pawan Mamidi at IIM Ahmedabad, which culminated into the Indian Association for Law and Economics, and this was under the guidance of Professor Hans Bernd Schaeffer, who has a long association with the law and economics in India, as I've already told you. The association has hosted 6 annual international conferences with host universities, and I'm happy to announce that the 2021 conference will be hosted by Tamil Nadu National Law University in December 2021, and I take this platform to disseminate this information and so that scholars can be ready with their research work for the upcoming December 2021 conference in Tamil Nadu. With regard to research, The center, in association with our very bright, interested and energetic student members, have undertaken research projects on criminalization of check bounce cases and efficiency analysis, Consumer Protection Act from the lens of the liability system as an exchange system, Constitution, a theory of bargain, impact analysis of work environment of disabled employees in the government organizations of Ahmedabad, Gandhinagar districts funded by the government of Gujarat, evaluating timelines and voting threshold under IBC and efficiency analysis, behavior response of COVID-19 pandemic law and economics approach. These have been led by my very competent team member, Dr. Hitesh Thakkar. The center has published 3 edited books: Law and Economics in India, Understanding and Practice, Routledge 2017, Economic Analysis of Law, An Indian Perspective, LexisNexis 2014, Law and Economics, Breaking New Grounds, EBC 2013, NPA Legislations, Himalaya Publishers, very recent 2021, for which I will later invite my colleague to talk. The center also publishes the Gujarat National Law University Journal in Law and Economics and has launched the special issue on COVID-19 in February 2021. This was very briefly about the center. We've had a journey of 6 years now, before which we worked in collaboration as a conference consortium with IIM Ahmedabad, IIM Bangalore, and IIT Kanpur. Talking about the conference, the Gujarat National Law University International Conference on Economic Analysis of Law, the present conference that we are a part of, is an outcome of the previous efforts mentioned, complemented by the ecosystem of this university, our faculty and students. The papers were invited on thematic areas of property, contract, tort, forensic crime, civil law, common law, constitution and election laws, laws on regulations and business, laws on economics of legal procedure, and on macroeconomics, law, and public policy. These are the thematic areas identified in the conference. 120 extended abstracts were received and put through review process, of which 72 were shortlisted. Of the 72, 55 full papers will be presented in this conference. The conference has encapsulated issues at the center of today's national debate, reflected by dominance of papers on law and finance, dimensions and impact of COVID-19 pandemic, and the farm laws. The conference will host 26 chairs and co-chairs for the 13 technical sessions scheduled, comprising of faculty in the domain of law and in the domain of economics from different universities across India. The conference has the distinct privilege of learning from distinguished plenary speakers, namely Professor Oliver Hart, Nobel Laureate 2016, Professor Kaushik Basu, whose brilliant session we just attended, Professor Thomas Ulan, whose book is the primer for the introductory studies in law and economics across the National Law Schools India. He will be speaking to us. Professor Ajit Sharma, authority in his own right in the area of law and economics, Professor Ram Singh. You already heard about Professor Ram Singh from Kaushik Basu sir. Professor Rajesh Parchure, the director of Gokhale Institute, Professor Prasad, who's a professor of economics at IIT Kanpur, Professor Jaiveer Singh, a professor of economics at GNLU. And so this has been a very long-term association. It is not just this conference that we have their esteemed presence, but it has been a long sustained movement in furtherance of law and economics. The guest of honor address for the inauguration is by Shri Injeti Srinivas sir, Chairman IFSCA. With these few words, I conclude my talk on about the Center for Law and Economics and about this conference. At this point, because we have a very recent publication coming up on NPA legislation, led by Dr. Hitesh Thakkar. I would invite Dr. Hitesh Thakkar to briefly introduce this very recent March 2021 publication. Dr. Hitesh, please.
Good morning, one and all present here. Prasant, can you just give me this sharing right? If you can just make me a presenter. I want to share the screen.
That's good, sir.
But it's not, it still does not come. Yeah, got it. Is it visible? Screen is visible?
Yes, sir, it's
It is
visible.
Is it book is visible, if I'm correct?
Yes, sir.
Is it visible? Yeah.
Yes, sir. Book is visible.
Yeah. So I respected chair and a guest of honor, Mr. Injeti Srinivas, respected director, sir, Professor S. Santakumar, respected Dean Madam, Mamta Biswal Madam, and a center head, Professor Anita Nagar. So I'm deeply thankful to Dr. Nagar, Professor Nagar, for introducing groups. So in Center for Law and Economics, I was interested to work on the GNLU NPA legislation research group. And under that, we were having more than 20-25 interested students who are interested to contribute in the NPA legislation in India. And we started this journey in, I think, 2017. And the fruits we are getting into 2021. So it was a lengthy task, but our interest was never ever publication. We were working because we were interested to do some research, some learning exercise through that group. But I'm happy that that with the consistent effort of my colleague, assistant editor Prominder and Sarthak, I think it ultimately we got approach from the international publisher also and national. But the book intend to make Indian legislation, so we choose the Himalaya publication for the book called NPA legislation in India. And though in law and economics we discuss about we make trade-off versus efficiency and equity, but this book do tell about that there is no requirement to make trade-off. You can get equity with efficiency. And in that line, the whole debt recovery legislation from RDBFI to SARFAESI Act to IBC to cross-border insolvency, some dynamic informal framework to recover debt. And what is the international perspective debts are recovered, that has been covered. And I'm deeply thankful to our director for writing a nice forward on why this book was required and what these books make impact. I think he has summarized in a very nicely in one paragraph that I will take in detail in the 11:30 session. And very interestingly, the Ram Singh sir has written a forward in the one paragraph. I think whole story has been explained with explaining the breach of loan agreement through the contract theory. And I think yes, nicely summarize the essence of what this book want to say. So I will not take much time because there is the session is there, but I'm very happy that in the big occasion, a big day, the books is getting released, and I'm thankful to all the researchers, and the guest researcher Kundavi Suresh and the Gorang Rami, who has contributed the paper and the research on the NPA legislation in India. So with that note, I am thankful to the university for providing me the opportunity to work on the NPA legislation, and also Professor Nagar under her leadership in Center for Law and Economics. I think this book is coming. So I dedicate a book to Dr. Nagar, a mentor and guide of mine. Thank you very much.
Thank you, sir, for discussing the publication. I now invite Professor Dr. Mamta Biswal ma'am, Dean of Academics and Faculty Affairs, and Professor of Law, Gujarat National Law University, to deliver the address.
Krishna, can you hear me?
Yes, ma'am, I can hear you.
Can you hear me?
Yes, ma'am.
Okay. Namaste, sir. Good morning, sir. So, good morning to everyone. Honorable guest of honor, Sri Injeti Srinivas, sir. Respected Director, Gujarat National Law University, Professor Dr. S. Shantakumar. My colleague, Dr. Ranita Nagar, the Director, Center for Law and Economics, and Dr. Hitesh and other members, the presenters and participants of this conference. A very warm welcome to all of you to this international conference on economic analysis of law and governance, and special edition for the young scholars. Having very limited understanding of this unusual combination of two different subjects, that is law and economics, I must say that the last 3 decades, plenty of research has been done and attempt has been made to make this area of research very impactful. But when I think about these two different subjects and the combination of these 2 subjects, many times these unanswered questions come that is it economic analysis of law or legal analysis of economics. So after going through all this research, and particularly my friend Dr. Nagar, many times we discuss, and what I understood that this particular research can help in the economic benefits of the individuals and also in policy making in the country by making different analysis through the economic theories. But at the same time, when we do this research, as I said that this is the combination of 2 unusual unusual combination of 2 different subjects. There are few points in my observation I want to share. The understanding of 2 subjects is very important. So it should not be one way that only knowing the law, one should not do this research, and knowing economics also we should not do. So understanding of both the subject will help in this research, because the young scholars and researchers are attending this conference, and the emphasis should be given on the object of the legislation. When we do the economic analysis of the law, many times, and particularly in India, the laws are either economic laws or economically beneficial laws. So when it is economically beneficial laws, then we should focus on that, is it really beneficial to the people for whom it is made. And when it is economic law, we can see the impact analysis of that law. Then another point is that when this kind of analysis and interdisciplinary research is concerned, the GLEC, that is the law of the place, should be given more importance. So the law of the place means here in law the principles, the concepts of one country may not match with the law and principle of the other country. Very recently, there was a judgment of Kenya Supreme Court 20 days back. So, in that judgment, the Supreme Court has pronounced a very interesting judgment where the landless, homeless people who were residing near the airport, there was a government order by the government of Kenya to evict that place and to demolish those houses. So those people aggrieved by the order of the some government, they approached the Supreme Court filing a writ like India, and there also it is Article 21. And the lower courts and also the appellate court, they were in favor of the government. But finally, the Supreme Court has pronounced a very interesting judgment and applying the international customary law that the people who are residing and who are the citizens of the country Kenya, they have the protective right, and they are very categorically mentioned in that judgment that that is their protective right. And under the international customary law where Kenya is a party, the people have the right to land in that country. But very categorically, the Supreme Court also has laid down they don't have any ownership right, but their socio-economic right to be protected. So that is why that particular judgment is called as a very progressive judgment, and to protect the economic right of these landless people. But when we consider that time also, it strike to me that that is a problem in India where so many people are homeless, landless. But again, the same thing that that is suiting to that country. But in our country, when we see the population, and the population there is somewhere 5 to 6 crore, where here 130 crore the area. So keeping in mind all those things, I think even though that is a progressive judgment for them to protect the economic right of the people, that may not be the proper law for us, or it may not help us, the government or the people, to apply such kind of law or in such way to protect the socio-economic rights of the people. So here what my understanding was in that judgment, and also many research when I see that different subjects, constitution, company law, or any other law, the law differs. The lex loci, law of the place, is very important. And sometimes we apply the theory and we forget that what is the principle in our country. Then the mismatch comes there. Even though we do the interdisciplinary research, but that mismatching should be avoided by the researchers and the scholars. That one theory which is very strong in a country, that may not suit, like contract act, privity of contract, which is different in different countries. Next is the point to be focused by the researcher, that is the academic honesty. Many times while starting such kind of interdisciplinary research, we forget that which laws should be really analyzed. A new law came or new legislation came, and then suddenly we start a research on that. But when we think about such kind of rare combination of two subjects, we should be very honest in our research. And one day Srinivas sir was also discussing that the research should be policy oriented. I realized that day that is the difference between academic research and policy research. when we do the academic research, we forget whether my research is useful or impactful. But then that time we don't realize. So now we should focus our research maybe in the policy making direction that is lacking in our country. Then is this different kind of the socio-economic welfare legislation that I said that when we see many of the Indian legislations are either economic legislation like the IBC or IPR laws, and also economically beneficial laws like labor laws or Consumer Protection Act, so that we should not deviate from the object of that particular legislation. Sometimes in a flow of research, what the researchers do, they deviate from the main object of the legislation. And that should not happen, that in the research, if we cannot give justice to the object of the particular legislation, then that research may not be useful also. Similarly, there are various areas of law where we can focus, because as Ranita ma'am said that in India, this is started in the last 1 decade, not decade, also 5 years. The academicians are making attempt to do research in this particular area. And in India also there are many areas like in Companies Act, when I talk about the CSR. CSR is one of the very economically beneficial provision, and after our honorable guest of honor, Injeti Srinivas' recommendation, high level committee recommendation, there are many recommendations which are really very useful and impactful. So it can be extended for the economic benefits of the people of the country. Similarly, this producer company, which is a very interesting concept in the Companies Act, and it was introduced in the 2002 Second Amendment to the Companies Act. And there are various issues of the farmers. I'm not talking about the pending this legislations that the farmers are facing problem or what they are doing, but the other issues, that is particularly the economic issues, that they take a loan, then they cannot repay, and suddenly they face certain problem due to different natural calamities, and then they become frustration, and they go to frustration and other depressions, and there this producer company concept can help them economically, because after this Vanilla India, the first producer company, which was a cooperative society in Kerala, after it was converted, the research shows that, the record says that it has been highly beneficial to all, and also those farmers who have converted, who are the producers in that company. So that is one concept where this can help the people a lot. So here all these are different areas that I wanted to share, that the young researchers and the scholars, they should more focus, because in law and economics or economic analysis of law, we are in a very preliminary stage, I'm sorry. So focus should be given to all these areas, and also while applying the law, many times we just apply the law very randomly, without knowing that whether this law is the proper law to be applied or not. And when, particularly when constitution is concerned, and here there is a very interesting point that my discussion with my friend Dr. Nagar, I think it is one unending debate with her, Article 21 of the Constitution, where I was having a doubt that how to apply this economic theory to Article 21 of the Constitution. Madam convinced me. She made many arguments, academic arguments that no, in this way we can do. So like this, there are various areas where the research can be very well done, and also certain areas are there where just for the sake of doing research we should not do. And while concluding these points, and I congratulate my colleague Dr. Ranita Nagar and Dr. Hitesh for organizing this international conference, and I have seen their enthusiasm in the last 5 years when our previous director, Professor Dr. Bimal Patel, started this particular center, and he has many times he used to push them that why don't you do the research, and currently our director, Professor is Kumar sir also always he encourages to them that why don't you do this research. But at the same time, when we are the academic researcher or researcher for any other purpose, we should be very careful and very meticulously we should do the research when the combination of two different subjects are concerned. And while concluding my apology to all, due to some technical problem in my system, I could not enter. And my apology to our guest of honor, Sri Injeti Srinivas sir, and I'm very sorry because of this technical problem I could not enter, and all the participants, presenters, everyone present here. Thank you very much, madam, and everyone for giving me this opportunity. Thank you.
Thank you, ma'am, for the important academic deliberation on the interface of law and economics. I'm extremely privileged to welcome our guest of honor, Sri Injeti Srinivas, sir. Sir is currently the chairman of International Financial Services Center Authority. While at the helm of the Ministry of Corporate Affairs, sir was instrumental in bringing forth significant reforms in Insolvency Bankruptcy Code and Companies Act. Today, we have the privilege to learn from his address on law and economics, a behavioral perspective. With the kind permission of sir, we would like to reserve 15 minutes for the question and answer session at the end. The participants are requested to post questions in the chat box along with the names so that the respective questions may be addressed. We invite you, sir, for the address.
Thank you. Professor Shantakumar, Professor Mamta Biswal, Professor Ranita Nagar, Assistant Professor Hiteshkumar Thakkar, distinguished guests, participants, and dear students. At the outset, I would like to compliment the Gujarat National Law University for organizing this international conference on law and economics and economic analysis of law and governance. I think this subject is of particular importance to us as an economy which is on the threshold of takeoff. We all know that prior to the economic liberalization, we were famous for the Hindu rate of growth. Post economic liberalization, our growth catapulted, and we have emerged as one of the fastest growing economies in the world and one of the largest economies in the world. Today, our aspiration is to grow even bigger to a 5 trillion economy from the present 3 trillion economy. Now, in order to achieve this goal, what role does economics have to play? What role does law have to play? This is the main issue which needs to be resolved. Is it possible that there is only economic consideration and no legal consideration? or we are obsessed with legal consideration at the cost of economic consideration? Will it impact growth? These are all important issues. Now, I am not a subject matter on law or economics. I'm not an expert, but I draw inputs from my experience, in my capacity as a regulator, in my various assignments which I held in the past and what I'm currently holding. Let me take the example quickly of pharmaceuticals, corporate affairs, and now the financial sector. India has emerged as the pharmacy of the world. Today, we are one of the lead countries even in providing vaccines to all nations. More than 70 nations have benefited from our vaccines. How has this happened? How we have become the most dominant supplier of generic medicines? Is it that the legal framework, the institutional framework facilitated this? Or is it only the pursuit of the business entities to maximize their growth and maximize their profit? Or is it an interplay between the two? Are social considerations equally important as economic considerations? Which will get precedence over the other? These are all very difficult and delicate questions. Very often, we, with hindsight, make a lot of observations on some laws. But that sometimes may not be a very fair assessment, because economic laws involve experimentation also. There is no definiteness when you are dealing with economic laws. In fact, the Insolvency and Bankruptcy Code within 3 years underwent 5 amendments, and it's ready for some more amendments. Now, does it mean that when we passed the legislation, there was no thought which went into it? Not likely. Not likely. Process of making law is always quite rigorous. The issue is that you were looking at uncharted waters. When you're looking at uncharted waters, you were experimenting. And the real success would lie in how responsive you are. So in a way, frequent amendments could be an indication of the responsiveness of the state to do mid-course corrections, to calibrate, recalibrate, so that optimal outcomes are achieved. Now, coming back to, let us say, pharmaceuticals. We have the National Pharmaceutical Pricing Authority. Now, that authority tries to control prices. Now, controlling prices is interference with market forces. Normally, demand and supply should determine the price. So, where is the necessity for prices to be controlled? Now, Dr. Biswal was mentioning about right to life. Now, let me bring back that concept of right to life. Everybody has a right to life. Everybody has a right to live. It can't be based only on demand, because demand is the willingness and ability to pay. But want is demand for something, but you may not have the ability to pay. But in this case, right to life, everybody has a right to life. Suppose in the COVID situation, your vaccine is priced so high that only 5% of the country can afford it. Then what happens to the 95% of the country? So even if you have patent laws and all laws, there are limitations put on them, there are carve-outs, there are exceptions to meet social requirements, to serve public interest. For pharma, therefore, affordability, availability, accessibility of medicines, essential medicines, has been the basic philosophy. So whatever is considered to be absolutely essential, the experts draw up a list of, national list of essential medicines, and those medicines are kept under some sort of price control. But non-essential medicines are not kept under price control. Similarly, generic medicines are kept under price control, but patented medicines are not kept under price control. This is one example, of law and economics. Because to produce breakthrough drugs, you need to invest billions of dollars. Then if you invest billions of dollars, you need to recover the money also. So if you put price control, nobody is going to venture into that area. And if you don't venture into that area, you will not have modern drugs to meet challenges, newer and newer challenges. But at the same time, if you look at the COVID-19 example, here you had to produce a vaccine, all countries put together, to give immunity to 7 billion people. And you wanted to produce the vaccine in months. Normally it takes years, especially for a broad spectrum sort of viral infection like the COVID-19. But then all countries came together, and even within India, the government and the private sector came together, ICMR and everybody, all put their resources and developed a vaccine, and trials were conducted under extraordinary circumstances, and vaccines were made available. And though in the normal course you would have to have a very detailed sort of trial system, here it was a shorter system, and under emergency clause you made it available. So here social considerations outweighed economic considerations. And whatever law or other rules, you needed to make some carve-outs to facilitate this outcome. What is important is the outcome. What is the desired outcome? Are you able to get to the desired outcome? What are the economic tools? What are the legal tools to be able to arrive at the outcome? Now, we see that some countries develop very fast. Some countries do not develop that fast, even though they may be similarly endowed in terms of natural resources. So there's a paradoxical situation. One country is having abundant natural resources, but it is not developing. Now, at one level, you can say that the differentiator has been the human capital. The human resources are very good. The financial capital, technology, these differentiators have made the difference. But more important than these factors, in fact, what actually leads to these being available to you are the underlying institutional environment and institutional arrangements. These institutional environment and institutional arrangements draw the boundaries of economic freedom. Just like civil liberty, there is economic liberty. but they are different. There's a slight difference between that. Civil liberties, we can't compromise, but economic liberty, sometimes you may have to compromise in public interest. Now, it is well established that economic freedom and economic performance have a positive correlation. They have a positive cause-effect relationship. That means the more freedom you give, the more the chances that you perform better. This is supported by empirical evidence, by our own experience pre-1991 and post-1991. Pre-1991, I'll give an example. I was in the telecom ministry in 1991 as private secretary to the minister. And those days in Delhi and Mumbai, you had to wait for 10 years to get a landline. And the greatest sort of demand of people used to be, please, out of turn, get me a telephone connection. Those days, for getting a Bajaj Vespa scooter, there was a quota system. You wouldn't get it. Today, within 1 hour, 10 companies will be ready to come and put their landline. The cost has come down. Now, what does this show? Earlier, state-directed policy was there. State was controlling that activity. The intention of the state was only to maximize the welfare of the people. But it had an opposite impact. Nationalization of roadways in most states, it had an opposite impact, contrary to what was intended. Now here, after liberalization, when you allowed private sector to come in, it created an environment where, with healthy competition and a lot of investment coming into the sector, it was a win-win situation. Government got more revenues, people got easy access to this telephony, and it was much cheaper. So this is an example that what will be the boundaries of economic freedom. If you make it totally controlled, if it's all licensed, it may have a negative impact. You see, let us take the example, because now currently I'm in the financial sector. Take the example of the market. A few decades back in the capital market, trading was physical. There was a physical hall, there were brokers, there was a limited number of brokers who could be there. And therefore, if a new entrant wanted to come, it was not possible. Till one retired or something, one vacancy fell, you could not enter. So there was no ease of entry, there were barriers. And the brokers controlled the entire trading environment, the rules of the game. But after, you had an electronic platform, unlimited brokers can be accommodated. Unlimited participants can be accommodated. There is 100% transparency. Information dissemination is also perfect. Very little information asymmetry. And the results are there to see. But when it comes to the stock exchange now, unlike before, we went with the principle of demutualization. That means owners and traders should be segregated. Otherwise, there will be strong conflict of interest, and you may pursue your interest at the cost of people. So this shows how closely the two are interrelated. Basically, it means whether it is the state making a legislation or whether it is a regulator making a regulation, you have to be very careful to ensure that you are serving the larger interest of the nation and not serving your own convenience. It is in this context that when the financial sector Legislative Reforms Committee was set up under Justice Sri Krishna, they made a very important recommendations for the financial sector for promoting efficiency in the financial sector. They said that the regulation making process, the rule making process should be very well structured, should be highly accountable, and should be transparent. There should be strong consultation with public and all stakeholders. When you come out with regulations, you should be sure that you have those powers with you. You should clearly state the objects and reasons why you are coming out with this regulation. What is the object? You should indicate what is the market failure situation you are anticipating or you're worried about. How your proposition will address that market failure situation. And last but not the least, the compliance cost to the society, will it be outweighed by the benefits to the society? Unless it meets these requirements, you should not keep on coming with regulations. Also, they emphasize the rule of law. You should not take action without knowledge of the law. Because that will not be appropriate. And there should be a proper appeal mechanism also. And there should be equality of treatment. In similar situations, you should treat people in the same fashion. So this is again a very important thing, that economic impact analysis should precede lawmaking. Actually, what has happened, our academics also have failed to achieve this fusion, because whatever they have achieved is very, very borderline achievement, marginal achievement. We should actually have legal economists. A person who is dealing with criminal law or civil law, they will not be able to deal with economic law. Let us say competition law. You can't deal, a normal, you can't deal. You need to have this fusion. A legal economist with the very complex issues. We can't just simplify them and, then we'll be, making a mistake perhaps. If you look at, now coming to liberty, we talked about liberty. Now, how do we compare economic liberty and civil liberty? Actually, civil liberty, by and large, is a legal matter. Your constitution gives you certain fundamental rights. Those rights need to be protected, regardless. But economic liberties fall into the domain of both law and economics. Therefore, the balancing act is very critical. What does economics want to do? In one line, if we have to say, the most efficient allocation of resources. This is what economics would want to do. What does law want to do? Law wants to dispense justice, fairness, equality, equity, efficiency versus equity. It is not a question of trade-off. It's It's a question of optimization, because both are interrelated. Trade-off is when they are mutually exclusive. But when they are mutually inclusive, it is getting equilibrium. So there's a difference between getting equilibrium and trade-off. Like mechanical and chemical reaction. So it's a difficult subject. Now, what is the central problem of economics? Inadequacy of resources. What is the central problem of law? Inadequacy of freedom. But luckily, they are counterbalanced by adequacies also. That is, you have limited resources, but you have alternative uses to resources. And similarly, firms try to maximize their profits. So, how do you ensure optimal economic outcomes? You ensure optimal economic outcomes by calibrating these two in a manner that you get the optimal outcomes, you do not get suboptimal outcomes. What is very important though in economic law is, unlike civil liberty, where conduct is almost entirely the decisive factor, here conduct and context both have to be seen. There could be a situation where the same conduct can lead to different outcomes. There can be a situation where different conducts lead to the same outcome. For example, look at competition law. There can be a situation where if you are charging a higher price, you may be guilty of abuse of your dominance. You're abusing your dominance if you're charging a higher price. If you're charging a lower price, you can be accused of predatory pricing. If you charge no price, you can be accused of creating an entry barrier. And if you charge the same price, you can be accused of cartelization. How you will determine the conduct in a context? If you are not dominant, if it is not a relevant market issue, then the violation does not exist. But if you are dominant, if it is in the relevant market, and if there is appreciable adverse effect, then it becomes punishable. So in this situation, you will find that conduct and context, all these things are to be very, very carefully evaluated. Now, if we want to broadly come to some sort of conclusion, I think economic freedom and public interest, these are the two principles it boils down to. Economic freedom is given by freedom of entry, freedom of operation, and freedom of exit. All are important. And public interest is a cross-cutting issue. The public interest issue would be there. Or we also sometimes expand it to national interest. There could be a national interest type of situation also, which may be slightly different from public interest as commonly understood. Now, if you look at our growth and our performance, by delicensing, by dismantling Inspector Raj, the ease of entry has been enhanced. Now more and more people are able to enter. You have startups. We are the third largest startup ecosystem in the world. How startups are coming? I know, as my previous assignment as Secretary Corporate Affairs. Now, we removed even the minimum capital you have to put. Earlier, it was 1 lakh of rupees you have to put if you want to incorporate a company or a public company, 5 lakh. Now, no, I did not put that amount. Nothing is prescribed. Maybe 1,000 rupees you can put. So the idea is in 1,000 rupees you can't do a business. But why to block the person? Person wants to incorporate a company and is willing to comply with the requirements after incorporation of a company, leave it to them. But there is an issue of responsible conduct of business. We were one of the pioneers to put it in law. Corporate social responsibility is not an act of magnanimity. It is a legal obligation. Though great economists and great investors like Milton Friedman and Warren Buffett have openly declared that there is no meaning in corporate social responsibility. This is the job of the government. And the only job of the firm is to maximize profits for its shareholders. Sorry. If that were true, why the whole world is talking about sustainable finance, social capital, green finance, climate change? Our Companies Act clearly laid down that every director, apart from acting in the interest of the shareholders, will act in the interest of other stakeholders. So whether it is business and human rights, or environment protection, or gender equity, all of these are important. So unrestrained freedom cannot be there. But at the same time, you need to calibrate it. If you do not calibrate it, you will have suboptimal outcomes. But there is no magic. There is no magic that you can calibrate it perfectly and get perfect outcomes. Everywhere, there's an evolutionary process worldwide. All economic laws, especially in the financial market, they look at protecting interests of depositors and investors, but at the same time want to give freedom to the firm to produce innovative products. But there has to be a balance. That means you have it, but you have to have a balance. Now, because it's experimentation, I have started off by saying it's experimentation. Please understand, experiment is not definitive. It's a lab situation. That is why regulatory sandbox concept has come. You have a regulatory sandbox because you don't understand it. So just like a vaccine trial, you are doing a financial product trial in a regulatory sandbox. Whether it can be live or simulated. And once it is tested, you're allowing it to be expanded. So these are issues which are important. Competition law, earlier MRTP was different. MRTP said being big is bad. Competition law says no, being big is not bad. But abusing your dominance is bad. And with the new economy challenges, some new issues have come up which the traditional framework of the law is not able to deal with. Therefore, if you have gone through, the new bill also has been prepared, and you have a competition law committee also which gave a detailed recommendations. This should be researched, because the Competition Law Committee looked at new economy challenges, digital economy challenges, e-commerce, other things, where the traditional parameters are not fitting. Now, finally, yeah, I think I'm running out of time. So finally, to conclude, ease of exit. This is the most important. Now, all this while we have done a lot on ease of entry and ease of operation, there was a blockage. There was no ease for exit. You could not exit. Now, if you cannot exit, then resources are locked up. When resources are locked up, resources are wasted. And you're losing growth opportunity. I do not have any firm, correlation, regression analysis with me or anything, but off the cuff, as an administrator, as a policy maker, I'm telling you, about 2% of GDP we have lost growth because of a lack of a robust insolvency regime. Now, that regime has effectively from December 2016 to 2017, 3-4 years, that regime has been there. But it has been on an experimental mode. We can't point fingers like this or that. There are issues. Group insolvency, nowhere in the world group insolvency framework has come yet. Cross-border insolvency has many unknown issues. There are issues. Pre-pack, there is an issue, whether it is transparent or whether the promoters are engineering something. But for the first time, you have a consolidated legal framework. The previous law, SICA, actually got abused. So it actually gave a license, contrary to the intention of the act, it gave a license and protection to the management to perpetuate their control over the assets, not pay the creditors, and continue to enjoy the assets, and actually, the assets which were locked up were decaying. The destruction of value was taking place. Now, the new law, has changed the behavior, of the people. The borrower's behavior. Borrowers don't want, to be a NPA. In fact, one CMD of a very big bank once told me, he said, let me explain you what has been the impact of IBC as I see. He says, before this act was there, whenever a big loan account went, into an NPA, non-performing asset, a junior employee of the company would even come and meet me and say, "Aapka account NPA ho gaya, aapka account, bank ka account." तो सब देख लीजिए, because his point was, मेरा तो कुछ नहीं होगा, आपका बैलेंस शीट खराब हो जाएगा. He says now the chairman and MD and everybody is queuing up and saying, "Saab, please, मैं पेमेंट कर रहा हूं, रिजॉल्व कर दीजिए." There has been an enormous impact. The NPA, as per RBI's own reports, reduced from 12% to 8%. These are RBI publications. Now it is again climbing up because of COVID, and there was a suspension of IBC and all those things. I think worldwide there may be issues. But what more efficacy do we want? From 12% it came down to 8% in 3 years. Which country in less than 3 years in our economic experimentation, we have not only come up with an IBC, but a whole new profession of resolution professionals has been set up, an information utility has been set up, the National Company Law Tribunal has been set up. There are issues which need to be addressed. So friends, I think I tried to basically draw inputs from my experience to relate it to the subject matter. And I would only conclude saying that a lot of research is required. Lot of research is required. I have been, very closely associated with this policy making and all. But my own experience is that I did not have access to very well researched, robust research material which could aid or give us a deeper understanding of the contours of the issue and how we should approach what were the international best practices. That's not there. Let's face it, it's not there. So, as Mamta has said, this is a nascent subject, it's a virgin area, you have enormous opportunity. And GNLU should try and become front runner in, making this Center for Law and Economics, a very, very coveted sort of center, and everybody should like to, take admission here and pursue serious research. Because without research, there is no gain. Theoretical concepts may be good, fundamentals may be good, but when you do not apply that knowledge is wasted. You're acquiring knowledge to put it to practical use, to research, and to give inputs which are based on empirical evidence. All aspects, behavioral aspects, other aspects. So I'm sure, having taken this initiative, GNLU in a short period of time has emerged as one of the top law schools in the country. I compliment once again Professor Shantakumar for organizing this conference and for giving me this opportunity. I may be excused if, due to lack of my expertise in the subject, I have deviated and gone more into, practical issues. But that's what will happen when you call, a layman like me to address such a gathering. Thank you.
Such a valuable session. Moving forward with the question. The first question has been asked by Dr. Hardik. He is an assistant professor at the MS University of Baroda. Sir is asking for your views on the present government's approach to move from 3 trillion economy to 5 trillion economy by raising the funds through privatization of nationalized banks.
So again, I think this is a very, 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 very good question, because why were banks nationalized? Banks were nationalized thinking that we will be protecting social interests, because poor people were not able to access banks those days. So when Prime Minister Indira Gandhi at that point in time nationalized banks, she wanted financial inclusiveness. So she nationalized banks. This is like, nationalizing the road transport in all states, that, you make it affordable to people. Now, that phase, at that point in time, that was a correct decision. But 40 years down the line or 50 years down the line, now we have a high degree of financial inclusiveness. We need innovation. We need efficiency. We need performance. And we need autonomy. So if private capital will come, and government, again, I think if I remember correctly, they said that 4 or 5 banks we will sort of go with privatization. Some core banks like State Bank of India and all, I don't think government is contemplating such action. But 4 or 5 banks they've identified where they'll privatize. So I think this is a very, very good decision, and this can really sort of rejuvenate these banks. Their market cap can go up very high. See, there's a problem. Let me just tell you. For example, State Bank of India, one of the best managed banks, let me tell you. It's one of the best managed banks. It's a sovereign bank. It has the largest coverage, serves 40 crore people. But its market cap is lower than Kotak Mahindra Bank. Now, this market capitalization is lesser than Kotak Mahindra Bank. That means its market cap is less than its own balance sheet. because people's perception, public perception, they think it's efficient, a lot of interference must be there, this, that. So I think we also, on the one hand, we should privatize or disinvest. On the other hand, we must professionalize the public sector banks also, which is highly feasible. So my response is yes, it is a very correct action, and it should be complemented by a very fast track professionalization of the public sector bank, so that a bank which is a well managed bank like SBI can increase its market cap 3 to 4 times.
Thank you, sir. Due to paucity of time, and I will take one more question. It has been asked by Aditya Sharma. He is saying that in a 2019 committee that was headed by you, there was a report published related to CSR. So in one of the recommendations proposed, it was said that CSR default should be made a civil offense. So will this change not lead to less compliance? And subsequently, what are the views on compulsory CSR, as in the end, consumers have to bear the burden?
So on the first part, the company law has gone through a complete decriminalization. If you look at Companies Act, there were about 130 provisions for penalty. And out of that, a large number of sections were involving even imprisonment. Now, imprisonment is not the answer. So if there's an overkill, it is more than sufficient to have a civil offense. Because if there is a violation, now in this case, that liability remains on you. So you have to contribute minimum 2%, of your net profit. As if you don't, then that liability remains. You have to make good that. So I think sometimes if you bring very onerous sort of punishment, it can be abused also by the authorities. We should not. And worldwide, in the modern economies, you don't have a criminality attached to this. In fact, you must be seeing in US and all, in securities exchange, security SEC, they are penalizing 1 billion, 500 million, but imprisonment in different situations. If there's an insider trading, imprisonment, no tolerance. That is, it's totally criminality is there. But if criminality is not there, they are not getting into imprisonment. So I think that part is fine. And your second part, I couldn't follow. How consumer is bearing the cost.
Sir, Aditya is asking that about your views on compulsory CSR. And on adding to that, he says that if the compulsory CSR is there, so the consumers have to bear the burden.
No, not at all. Because this is not being passed on to the consumer. You see, after you have done your pricing, after you have done your sales, after everything, you have got a net profit. Out of that net profit, 2%, before tax, 2% you are allocating for CSR. And what all activities are covered under CSR, these are all basically aimed at, giving society the benefits. So society will not have costs. Society will only have benefits. And making CSR optional is a flawed approach. There is nothing optional. Once CSR is there, it has to be mandatory.
Thank you, sir, for such an insightful session. We apologize to the participants who have given their queries, but we won't be able to cater to them because of paucity of times. So I request all the participants to mail their queries to us so that we can forward it to Injeti Srinivas, sir, so that your queries can be catered to. And once again, thank you, sir, for taking such a valuable session. Now, I would like to once again invite Professor Dr. Ranita Nagar ma'am to address the question.
Chairman, sir, thank you so much for your session. When experience speaks, it speaks way louder than theory. So we learned from experience the real interface of law and economics and the finding of the equilibrium and not the trade-off. On that note, I am happy that we just received this publication that we were mentioning, led by Hitesh sir and students. So this is actually a work on NPA legislation wherein the equilibrium of equity and efficiency has been explored. And if you permit us, we would like to reach this publication to you, sir.
Thank you. Thank you.
That's thank you. Krishna, please take.
I'm pleased to reach the conclusion of the inaugural ceremony. For that, I invite Dr. Hiteshkumar Thakkar, sir, Assistant Professor of Economics and convener of the conference, to deliver the vote of thanks.
Good morning, one and all. I feel it and I believe it that it's a great privilege as a convener of GNLU International Conference on Economic Analysis of Law and Governance to thank all the contribution and effort which will facilitate the objective of Center for Law in Economics towards creation of interest, awareness in the legal study using economic tools. So there is no competition between the law stream and economics. It is a bridge where the both are having a cooperative solution. I place on record our deep sense of gratitude to our beloved director, Professor Shantakumar. I think, sir, for the faith response in the Center for Law and Economics and the constant support. Without, I don't think this conference may be have possible. I should not miss the guest of honor, Sri Injeti Srinivas, sir. I think, sir, your session was, we can say it was not only theory, but it was practice. And you clearly mentioned about, you don't have to trade off between efficiency versus equity. I think you may have some cooperative between both. And I think what examples you have given, I think nice. And so you'll be surprised when I'm learning something about IBC, I always go through your videos, which are available in YouTube. Recently morning, I was going through that Columbia school where you mentioned, you're discussing about IBC, how India is rich. So background things, what you discuss, I think, like it make us more clear that what was the phenomena from the government side. And you tell real story. You don't tell anything, the gaps. You tell whatever the supply side leakages were there into addressing that. So with that, I think as a researcher, we get a good insight to do research. And sir, it's great that you are putting all the material in the YouTube and public domain. Thank you very much, sir.
Thank you. Thank you.
A heartfelt thanks to Professor Mamta Biswal, a Dean Faculty Academic Affairs. I think, Madam, you have rightly said that the core of law and economics should not be create a miscommunication. And I think that's why the UGC and this conference is there, where the experts and the stalwart in law and economics make sure that nobody is going and telling the wrong result. So I think it's good platform where you can recheck what you are telling, and I think what you are saying, that is also making sense. Like these two are a good partner, and I feel they are the good friend, they are brothers. So I think there's a long term. The law and economics both can go. That's what I feel, and you rightly addressed that in your inaugural address. Our beloved Registrar Jagdish Chandra in absentia, and the Dean authorities and my esteemed faculty colleague. I think in GNLU, we always want to interact in the faculty seminar, and it's not faculty seminar, it's a discussion seminar, and where it makes sure that whatever the limitation we are having from the law background side, they take care, and whatever we feel from the economic side, we do say, and they take in a positively, and we come out with the positive outcome, a cooperative outcome. So I'm always thankful to my faculty colleague and all GNLU family member. I think without their support, I think what about this conference, whatever previously we have done, we may have not make it. And sometimes we happen that the conference happen in the isolation. There is force behind the conference, and I think we should not miss. And it's a special thanks to my guru, to my mentor, Professor Ranita Nagar. head of the Center for Law and Economics, you always say that you have to lead and you have to take the Center for Law and Economics to the further level. I feel that it's going quite well, and we are working under his umbrella. And I think what we have achieved, I think if we sustain for 10 years, I think there is no question that where that GNLU will not progress. For only Madam point of view, generally Madam used law and economic concepts, so I'm also telling one. Her expertise always help us to removing the negative externalities and ensuring that marginal benefit is higher than marginal cost. So she makes sure that in cost benefit analysis, the benefit always higher than the cost, and we come out with that positive outcome. We have been fortunate to have renowned identities from the academics, law and economics, Grace Plenary session, which will ignite the minds of young scholar like me and other young scholar and introduce a magnificent world of law and economics. And these plenary sessions are successful because the morning opening batsman was Dr. Kaushik Basu, and the pair was Injeti Srinivas, sir. I think you have made so high benchmark that middle order and lower order also has to perform like that. And we are sure that the other upcoming speaker like Oliver Hart, the Nobel laureate in incomplete contract theory, and subsequently the landmark speaker, Professor Thomas Ulan, Ajit Mishra, Professor Rajesh Pachuri, P. Mulli Prasad, Professor Jaiveer Singh, and Ram Singh sir. So Ram Singh sir is the last batsman, and we know that he will make sure that the same zeal and enthusiasm will be there throughout the 4 days. So we are very thankful that you have accepted our invitation, and we are making a landmark achievement in this conference. Sometime what happened, we miss out the ground level people. I want to thank my all reviewer. I think they have worked day and night to shortlist paper, and over and above they have to chair in the 4 days. So we are struggling like anything, but they are accepting because they have ignite mind to learn law and economics. So we are really thankful to all reviewer, technical committee, chairs for accepting our invitation and doing work very meticulously. It was so surprised that we thought that we'll get 100 paper, not more than that, because it was only 20 days short notice. And we got so many papers, and then it was so tough that which paper not to accept. I think it's sometimes we feel that this conference should be of 1 week, so we may have given all young scholar time, but with the limitation time, we made that at least the 50 best scholars should get chance, so they are presenting in the conference. So after reviewer, the contributors, the paper contributors had challenge not to the reviewer but to the organization committee. They have done a wonderful job, and it will be very tough for all the technical panel chair, co-chair, and I'm sure that there will be a very learning exercise, and center will have come out with the incentive that the best 5 paper will be a monetary reward is also there, and we will publish in our journal, and remaining will be we are coming out with the book proceeding. So we hope that you put your points very strongly and make sure that you give yours what thoughts are there to the reviewer. So lastly, only 1 minute, because these people, I think these are our organizing team. So if I want to start, then I want to thank my coordinator of conference, Prashant Kumar Tiwari. I think he has worked day and night for this task. So he was the main person responsible for all the tasks. And I believe that in GNLU, the virtual part and technical knowledge, what Prashant is having, it make our job very easy. So I'm very much thankful to the Prashant for his leadership, showing a coordinatorship in the conference. And our student leaders, Abhishesh Sharma and Samida Mathur, I think both have done wonderful job, and I think it's great that we are seeing this day. And our panel moderator and the secretary of the conference, Krishna. I think Krishna make sure that wherever there is a breach, where there is a gap, she come intervene and she makes sure that the conference go with the upmost the height. It's it is unfortunate that I cannot name everybody because of because of limited time. But I'm thankful to the authorities, deans, colleagues, students, and organizing this conference successfully. Thank you for joining us in this conference. Thank you very much.
Thank you.
Thank you. Thank you, sir. The conference wouldn't have been possible without the guidance of Dr. Hiteshkumar Thakkar, sir. Hence, here we conclude the inaugural ceremony. We thank the esteemed guests and dignitaries in their presence.
Thank you.
Thank you, sir. Moving forward.
Thank you, sir. Thank you very much.
Thank you.
Proceeding forward, we take this opportunity to request Dr. Hiteshkumar Thakkar, sir, to discuss the recent GNLU Center publication in March 2021 on NPS laws in India, led by Dr. Hiteshkumar Thakkar and NPA Research Student Group. I'll request sir to discuss the publication in detail.
Is it screen is visible, Krishna? Can you see it?
Yes, sir. Yes, sir, I can see it. It's visible.
Yeah. So sometimes when you want to talk about your own book, it becomes very difficult. But I will try based on the time given to me, and so this is not research of 1 year; it is research of 3-4 years, and I think. I can't say that I'm the expert on NPA law, or debt recovery law, or insolvency law. Just I'm still learning, and I think I'm still in kindergarten, nursery. So I will discuss basically in this book we have discussed very basic and nursery thing. So on that note, I will discuss the NPA laws in India. So this is the book, and I think I'm thankful to all the expert and in the presence of that this book was launched, and I think it's Dr. Nagar. She always forces us to do something, and I think I'm thankful that she asked me to conclude the book. So otherwise, I was thinking to publish not before 2022 or 2023 because we were having some interesting research in COVID and this NPA legislation. So Madam told you can go with the part 2. So I think with that, I think we compiled 15 chapters. So these are the 15 chapters which discuss in this book. It take care from the overall essence point of view of recovery of debt, then understanding from the corporate world point of view, then understanding the behavioral law point of view. Case study also has been taken, SBI and PNB. Then the main legislation are DBFI Act, SURFACE Act, IBC. Also IBC comparing US versus UK, the cross-border insolvency, overall gist of all these 3 legislation. And the last paper was the COVID and the insolvency law and the deterrence effect of forecast-based analysis of CIRP. Sometimes it becomes very tough for the forward writer, and I'm equally thankful to the Professor Ram Singh. I think he has made the point in this paragraph in which it's made clear that what the authors is intend to do. So what he's saying, the loan agreement is a form of contract between the bank, financial institution, and loan taker, maybe individual or corporate. When debtor and creditor are in repeated relationship or fear of social sanction, both sides want to abide the terms of condition of loan agreement. In the contract, debt contract signed by bank and NBFC lack force of special pressure or mutual interdependence between borrower and the lender. So there is real chances of breach of loan agreement by the, so there are genuine breach also. We are not talking about the willful default, but there's also possibility of willful default also. this unanticipated breach of loan agreement lead to the problem of NPA. So what is telling, I think it's making the sense of what law and economics language want to tell about what is the problem of NPA. So the bank may follow moral pursuance mechanism through reminder notice to recover their due. Bank they don't want to use recovery a law first. They want that it informally, if it's recovered, then it is good. If it does not work, the bank need to use the appropriate recovery tools from a DRT, DR18 individual partnership firm, NCLT, NCL18 corporate companies. Yeah, maybe in a mortgage-backed securities are there, then SARFAESI Act and Lok Adalat as a form of mediation. So there are valid concern of adjournment and transaction cost involved in legal process. Therefore, the loan agreement need to be drafted and interpreted in such a way that the non-cooperative outcome can be transferred into the cooperative and mutually beneficial outcome. That's what he has discussed, and I think whole essence has come out for what is the breach of loan agreement means. And our beloved director has already said that this book is not about the to understand NPA laws from only one dimension. It has taken care of the multidimensional part, and these books provide the one-stop shopping and one-stop place where you can understand the debt recovery legislation. That's what the essence is telling. So when I was doing research as an economist, we do go with the theoretical framework. So the theoretical framework here was that if the debt recovery tools are recovering the NPA, that means whatever the NPA is there, which has not recovered through the informal mechanism, then bank go to the formal mechanism and use the RDB FI Act, maybe go to DRT, DR80, and in IBC go to NCLT and NCL80. Now, so that means that NPA and recovery tools should have a inverse relationship. That means as NPA, as you get more recovery, the NPA should reduce. So that was the thought in the author mind. So that there should be inverse and negative relationship between NPA and debt recovery tools. That was the theoretical framework. In law and economics, already we discussed was efficiency versus equity trade-off. So in that context also, it is impossible to make a 0% NPA. There will be a certain NPA, maybe 2%, 3%. We should not use, but in economics, sometimes word is used efficient NPA. That may be how much percentage of NPA the bank can take risk. That may be called efficient NPA, but it's impossible. If you make it 0, that means you're not allowing the financial institution to do her job more flexibly and more autonomously. So there is a possibility you can't have a 0 NPA. And there are instances of genuine loan default of NPA due to externality problem. So here the recovery tools want to make sure that there is no free rider and there are no willful default, yet there are no financial fraud taking because of this recovery mechanism. So that's what we are focusing through recovering our due through this legal framework. So various author has done research, and I think it's very extensive research is available in public domain. And but what is different in our study? That's what I want to discuss because it's a limited time. So let's go with the very simple game theory what Professor Basu was telling. So let's take IBC as one of the example. You can take individual insolvency also in same way. That means financial creditor, operational creditors. Just 1 minute. Yeah, sorry. So what I was saying that the financial creditor, operational creditor, a corporate debtor under the in the IBC, if their loan, if their due is not been paid by they have not paid by the debtor, then they can go to the NCLT. Generally, we are not discussing this segment where the cooperative outcome is there. Generally, the loan are given and party paid. So that is a cooperative outcome. Generally, we are discussing here the breach of loan agreement. So the default loan which is not paid according to Indian standard 180 days. New definition also has come, which is special mention account 0, 1, 2, where 30, 60, 90 days is there. But assume that we are going with the 180 days. So dues are not paid for at least 3 months. Sorry, yes, yeah, for 6 months. Then it will be considered as a NPA. In also 90 days is norm in India, but in international level we have seen it is 180 days. So so how to make this non-cooperative outcome to the cooperative outcome? That's what the theoretical background is there. So the aim of a code is to create deterrence or high cost. Like if you just go through all the lectures of insolvency, and our Center for Corporate Law and Insolvency also have done various programs. And when I go through the speakers, they're saying that this is a highly creditor-centric model, and debtors are given the deterrence signal. So deterrence is nothing but it is a high cost if you are if you come to the prospective insolvent. So if that happen, if there is a high cost and prospective, if you become prospective insolvent, then what will happen? Automatically behavior will change. People want to pay due in the time interval. And we have seen the data also saying that in operational creditors where due was very small, that also has recovered, and they have given very sincerely, and they make sure that they pay due in the given time. So what this game theory want to say, that there is a possibility that when CIRP is initiated, and the framework is like that NCLT, NCLAT go with the intent of legislation. So they are not allowing anybody to misuse the insolvency law. So there is a high cost to debtor if default take place. If that is the case, then automatically deterrence signals will get. And generally, what will happen? There will be less insolvency matter will come in the future in repeated game theory. People come to know that if you are defaulting and if you are not paying once, then the music of IBC you have to listen, and it is very tough music which you will not interested to bear. So now what is happening? They're telling to mouth to other also, and in that the less matter will come in future. And assuming people go to the highest authority, a tribunal court like Supreme Court, there also the court make sure they go with the true sense and intent of legislation, then also default will reduce. That is a high cost. Vice versa is low cost. So whether the current IBC is high cost or low cost, that you think. Like low cost means if you default and if you're not paying due, then also there's nothing you can misuse the institution like anything. So if that is the case, then there will be no deterrence. People will be interested to default. So and there will be more default take place. And assuming the highest court, Supreme Court is taking the wider, broader interpretation of legislation, then it may further delay and unnecessary. It will create confusion, and the IBC may not be working as per the standard, as per the intent what was thought. So let's check. NPA laws aim to create deterrence to debtor, empower the creditor. So whether it is high cost theory or it is a low cost theory. Now, when you discuss about the IBC, there are only two output possible. If input is what? The default, liquidity problem by companies, LLP, partnership firms, individuals. So output what they want, output may be resolution or revival. So that is the best output, and that's for that purpose the IBC was intended. But there is a possibility that if no resolution plan agreed, then it may lead to the liquidation. So there are two possible outcomes, resolution or liquidation. So these are the multiple the framework which take care of debt recovery. So I'm not going in this. Now let's check what was the how far the bank point of view the NPA was there. So if you see in data here, clearly the scheduled commercial banks were facing more problem, and in scheduled commercial bank, the public sector bank, clearly you can see the public sector bank is the tallest, which we are facing the problem of NPA. And then the new private sector will become. So gross and net in both the case, the problem is in the public sector bank. Now, in public sector bank, the notion was that when I was doing research, I was arguing with the madam that there is a problem in the private sector lending. And she was telling, no, you recheck the data and confirm it. And seriously, when we recheck it, then we found that there are the problem in non-priority sector lending. So in public sector, non-priority sector lending, that means corporate lending, and that was the major problem rather than the government intent to lend in a priority sector. So most of the default NPA was not paid in the non-priority sector lending. Now, whatever the defaults are there, how these recovery mechanisms are being used. Clearly, if you see the data of the number of cases referred, the Lok Adalat is a place where the first matter go, and we want that through mediation, through a mutual understanding between the bank and the defaulter, debtor, they pay some due and some discount given to them. There's some compromise made by the bank. So most of the cases are referring to the Lok Adalat. Whether it is efficient, we'll see. And second, in a mortgage-based SARFAESI, and then the DRT. Now, when you see from the point of view of the recovery, the data is clearly saying that SARFAESI is recovering their due. So in comparatively more than the DRT and then Lok Adalat. But this surprising, see what Lok Adalat is doing. People are going and doing forum shopping. They want to delay the process. They want to pay due, but not today as much as it can be delayed. So clearly the Lok Adalat is not efficient for the recovery point of view. What are the reasons? That has to be rechecked. Some empirical studies required, going to the Lok Adalat, talking with both the debtor and creditor, and from the who is presiding that matter. Now, people do say that SARFAESI was a very stringent law. And as an economist, when I read the clause of the SARFAESI, I find that it is a very stringent law. So that means SARFAESI, after SARFAESI, there should be good recovery of NPA may occur. But clearly see the data. Data is clearly saying that the pre-SARFAESI, whatever the debt is there, and post-SARFAESI, whatever the debt is there, clearly the post-SARFAESI debt has increased significantly. So whether we can say the SARFAESI is stringent or not, that is a still big question. Now, if you recall, initially I was saying that there is a direct relationship, there is an inverse relationship between these recovery tools and NPA. You see here, it is clearly showing that it's a very strong positive correlation is there. So what does it mean? It clearly means that the output of recovery done by the DRT, SARFAESI and Lok Adalat is not significant. And there are new NPAs are coming. So suppose NPA was 100 and this NPA recovered by the bank, by this DRT, SARFAESI is 10, 10, 10 to 30 is already recovered. But now it is not 70, additional 100 has come. So now NPA become 170. So whatever recovery you are doing, it's still not significant up to what new dynamic NPAs are joining. So that's why it is showing positive and strong correlation, and that shows that there is an inefficiency prevailing in the recovery framework. So this thing already discussed. Also, sometimes a bank doesn't have any option. They write off their account. And generally, if you talk write off and NPA, there should be inverse relationship. Clearly, you can see that there is a strong strong correlation is there. In fact, it should be a negative correlation should come, but it is coming positive correlation. That means write off also you are doing, and more NPAs are also increasing in the system. So that also shows that write off should have reduced NPA for the balance sheet point of view, but still it is not reflecting. Now, from the point of view of, I have used this regression model, and we found that if you talk about the recovery point of view, in 2003 and 2016, if you take 2003 to 2018-19, in both the case, the recovery is comparatively higher in the SARFAESI than the DRT and then the Lok Adalat. That means the estimated coefficient time is 2028.1818. This indicates that every year there is an increase in 20 to 8 billion in SARFAESI Act amount recovered during 2003-4 to 18-19. So that means recovery is still better in the SARFAESI compared to the DRT and the Lok Adalat. So what I was saying, it is like this only. There is a slow outflow of ongoing debt recovery cases, where there is high inflow of net debt recovery cases. It also reflects that existing debt recovery framework are not creating deterrents or high cost to the loan default. That's what the researcher want to make a point. So same thing, you can write that due to both high inflow on new NPA cases, low outflow, pending lawsuits are there. Pending lawsuits are there. Justice delay is also justice denied. So how much time I have, Krishna? Can I take 10 minutes?
Yes, sir. You may take 10 minutes.
Yeah. So, so I'm skipping some of the theoretical. I want to come the forecasting data analysis. So now what researcher has done, researcher has used ARIMA model and taking the time period till quarter 2019, quarter 3. So from 17 onwards data were there up to 17 4 quarters, 18 4 quarters, 19 3 quarters, taking that data and forecasted for quarter 2019 quarter 4 and 20 quarter 1, 2, 3, 4. So we want to forecast how many new CIRP cases will coming, how many liquidation cases are coming, what will be situation, the case filing by the financial creditor, case filing by the operational creditor, case filing by the debtor, corporate debtor, from 19 quarter 4 to 2020 quarter 4. I have rechecked and it is coming near to that. It is, there is nothing difference is there. Only despite only the moratorium, the relief given by the government from March 25th 2020 to 24 March 2020-21. Up to that scenario, this data are not telling truly, because the government has given relief and government has given a moratorium for at least 1 year to all the upcoming default. So let's go with this. So if you see this model, the red line is a variable which are saying that number of CIRP cases are increasing, and blue line is model line. And what has been forecasted, clearly forecast, is that more number of cases will be there in the quarter 4 to quarter 4 19 to quarter 4 2020. So I think if you take out 2, 3, 4, then quarter 4 to quarter 1, I think this result was reflected. So what was intent? I said it is high cost, and the signals getting to the debtor that if you are defaulting, then you have to face music, whether that music has been listened by them, whether they are understanding high cost. Still it is low cost and people are using the system for further delaying the time. I think there is no other way around. They are delaying time. Yeah, later on it may be go to the liquidation. So suppose let's check what is the status of liquidation. In liquidation also clearly you can see that in the forecast here that in quarter 19/4 and quarter 2024, the more liquidation will be there. So I don't know whether intent was for rescuing company for resolution, yeah, the killing the company through liquidation. So if more companies are getting liquidated, then economic big losses there. You can see point of view of employment and many other things. And there may be possibility of the market failure if we don't help some of our enterprise which are working from long time, and due to short-term liquidity problem, they are coming in that phase. So liquidity, so the increasing liquidation also is not a good signal. Now try to understand that who is running all this show. And in the IBC, the show is run by the resolution professional. Somebody also tell as an insolvency professional. And who appoint them? Insolvency professional agency. See the data that it is increase, decrease is there. And what forecast is telling that the new IP and resolution professional they are coming, but they are coming in the constant rate. But tell me, new cases of CIRP is also increasing, new cases of liquidation is also increasing, and IPA is also in the constant rate. So what does it mean? Don't you think that same IP previously dealing 3 cases now is to deal 7 cases? And in IPA also there is no further new IPAs are coming, new insolvency process agencies are coming. That means earlier the burden was to judiciary, now burden maybe to the IP and resolution professional, and we are asking over and about the economics of scale them to work. So there is infrastructure requirement is there. We required more IP. if the signal what this result has shown, then we required upward sloping the resolution professor, insolvency professional in future. So this is what I mentioned here, that there are possible higher cases of CIRP liquidation in the upcoming quarter, and moreover, this positive trend of CIRP and liquidation should be synchronized with the positive trend of insolvency professional and insolvency professional agency. But there is a constant trade pattern observed in IP, IPA. Therefore, there is a possibility that IP may not have to deal more cases for IP have to deal more cases of CIRP and liquidation. So it will be in a burden. Now, very interestingly, if you see that how many cases are filed by the operational creditor and financer. So generally we see that trend is higher with regard to the new cases filed was operational creditor, and then you can see this cyclical pattern is there in the financer creditor. But I think all of you are knowing that recently amendment of threshold increase from 1 lakh to 1 crore. I think this trend will not be observed from the that amendment onwards. So whenever the beneficiary relief period will over, that means 25th March onwards, the threshold amount which are less than 1 crore from the operational creditors are not filing this process. So there is a possibility that earlier operational creditors were getting benefit and they were using the IBC forum for recovering there. Now further they have to face the music of civil code. They will file civil suit to recover. Yeah, I don't know whether they can go to DRT and recover. That has to be seen. And operational data, I think we are clearly getting signal that is coming a reducing trend. So I already mentioned that the threshold 1 lakh change in 1 crore may have moderate effect of number of cases initiated by financial creditor and operational creditor. So the CIRP initiated by corporate debtor show this stepwise downtrend, which may be due to either high cost involved with regard to willful default. They know that if you are doing something wrong, then and you are the willful default, your exit is not free as described in the perfect competition. So they have got clear message. It seems like. So if I want to summarize, if I want to conclude, a deterrence and high cost to prospective insolvent is meaningful if there is a change in behavior pattern of group of insolvent. But data is still predicting there will be more CIRP liquidation process taking place. Whether there is a clear message reached to the debtor about the IBC stringency, there are still issue of infrastructure facility in the case of IPs. IPs are more deeply demanded than supply and shortage of IP. Thing I am discussing pre-COVID relief. What will happen in the post-COVID? That will be quite interesting to see, and that's what is there in the. There are some papers are there in the technical session. So with that note, I am thankful to the organizer, Ranita ma'am, Mamta ma'am, Professor S. Santakumar sir, and all my esteemed colleagues. And for giving me opportunity to showcase my research on NPA legislation in India. This is only very small part I have discussed, and I got very limited time, so I have taken only very small issue. But that is interesting to, if you go through the book, there are interesting things are there, and that will solely give a different perspective of understanding NPA legislation in India. In record, I want to thank Professor Ram Singh and Professor N. Santakumar for writing the foreword, and my assistant coordinator, assistant editor, Sathak and Prominder. Thank you.
Many congratulations, Hitesh sir.
Thank you, madam.
Hitesh sir, can you hear me? Many congratulations.
Yeah,
I'm
madam,
very happy to see you. And
thank you, madam.
Actually, I have a class, but I stayed back because of your book. And it was really very good. I just had a very quick look at the book. Very interesting book. So maybe we'll discuss some point of time in faculty seminar.
Sure, madam. I think under your guidance, we can further enrich an new book, something additional.
No. You have done such a good job. And again, congratulations. And to you and madam, even ma'am is not there, but I know she is involved in that publication also. Okay, thank you so much, sir. Thank you.
Krishna?
Thank you, sir. With this, we conclude this session.
Hearty congratulations, Dr. Thakkar, for the very good publication.
Thank you, madam.
So with this, we conclude this session. And I once again request all the participants to mail the queries that were not to, so that we can forward it to the respective resource person. I announce that the first technical session will start from 1 p.m. today. The links to join for the technical session has been mailed to you. It is a humble request for presenters for today to join using the link sent to them with the information of the respective. Thank you, everyone.
Thank you, Krishna. Thank you very much, Krishna.